lot of the concerns concerning the anti-counterfeiting trade agreement the ALDE had, well, the Commission sort of comforted us that these worries should not be taken too serious because they will stick within the boundaries of the acquis communautaire. So the Commission today told us we will not have a three strikes out within this agreement. There will not be any third-party liability of internet service providers. And if that is the message, then I hope the result will be the same.
I want to make the case with respect to three things about why at least I'm concerned with ACTA, and I think many others ought to be as well. The first has to do with transparency, no big surprise. Second has to do with the substance of the treaty based on the leaks that are now widely available. And then thirdly, and perhaps even most importantly, some of the long-term implications that I think come out of this ACTA process. I think it's critical to first recognize that those that are concerned with ACTA are not pro-counterfeiting or anti-copyright. Now, it seems to me that this has at times been a very easy smear to make. Those that suggest that there are problems with ACTA are somehow against copyright, against potential reforms for copyright, and are somehow pro-counterfeiting.
What is the impact of ACTA on innovation and newcomers? And the simple answer to that for me is, if they, the negotiating parties, get ACTA right, then the impact is either going to be minimal or nothing at all. Because, as so many people before me have said, this is a negotiation of the willing, and of the ones who actually have proven that they already know how to enforce intellectual property rights.
An exercise like today, I think, is extremely useful because the more we can exchange and the more we can go into details and explain what is our negotiating position, the better it is. I should add that the Commission has requested to ACTA partners the release of the negotiating document so that everybody can see that we do what we say and we say what we do. And we hope that in the next round in New Zealand next week, we will have the agreement of the other parties to do so.
The Parliament decisive role comes only at the very end, when the agreement has been negotiated and it has been signed. But through Article 218(6), now it's clear that the consent is required for all agreements in the field of which ordinary legislative procedure applies internally, which changes a lot the situation in relation to the pre-Lisbon, because now, of course, the Commission knows even before they propose the draft negotiating directives whether they will need the Parliament consent or not.
The ISPs have little capacity to mount any kind of defence on your behalf. They've got limited procedural recourse to do so either. They don't have the commercial incentive to do so. And, by the way, these things are also undermining the ISP's rights themselves. When a copyright holder complains that copyright has been infringed by an end user and says that the ISP must do something about it, whatever that measure might be, the accused, the internet user, has got a variety of defences that they could make.
The ACTA agreement is supposed to deal with the prevention of trade in fake medicine, counterfeit batteries, for example. And such trade in fake medicine and other products is a real hazard for people. So they can be concerned about what they're consuming, what they can buy on the internet, etc. The challenge is that we don't actually really know what is at stake, because there's been no formal transparency or insight for European citizens, stakeholders, the European Parliament. All we know now is actually through leaks. And so what we've asked on behalf of all those Europeans who were here today, but who were also at home, is that there be more transparency in the stake, in the starting point that the European Commission goes into these ACTA negotiations with.